We are here on my client's motion for summary judgment on the claims by Ms. Ruth Bittner against my clients. An original complaint was filed in this matter, and I think that the starting place for me is looking at what the allegations were made by the plaintiff. And the plaintiff in this case made an allegation that these are neighboring parcels and they share essentially cement in front of them that is a driveway. That driveway runs back, and plaintiff in her complaint describes a slab between the driveways up to the edge, and that there is a walkway that is closer to plaintiff's home that she describes was installed, and that she uses a cement walkway to access her backyard for groundskeeping and equipment. But by nature of the complaint that was filed, Ms. Bittner talks pretty clearly about the fact that at issue is this cement driveway that is sort of, I guess, between the parcels, or at issue between the two. My client has owned the property. Both these parties have been on these properties for a period of time, and I think there's a dispute as to if plaintiff has resided on the property for the entire period of time. My client has alleged that she has not, and it looks like Ms. Bittner has alleged that she has. But regardless of that, the reality is that the claims made by plaintiff are attempting to assert possession, adverse possession over a shared cement space that has essentially been a driveway. Even in her complaint, she talks about that previously the driveways did not adjoin, so there was land in between them, and that roughly 40 years ago that there was a cement slab between the driveways that was installed. The parties came to have a dispute, and that's what led to this be filed as a result of some of the issues that had happened between the parties. My clients did get a survey of the property and install a fence on the boundary line in an attempt to limit the conflict that had been occurring between the parties. And that was the Exhibit B that, to my declaration, shows sort of the landscape of what we're talking about, which is that there's a concrete driveway going to the Gray's property, which is my client, and then a concrete going to Miss Bittner's property. And then it reflects where there is an easement in that area, and then shows kind of where the disputed property is, which is where the fence line was placed on that property. My clients did place the fence line again in response to some of the issues that they had, and then that fence placement and the dispute of the same really led to this lawsuit being filed. The issue with the lawsuit and Ms. Bittner's claims over essentially a concrete piece of land that they use for a driveway is that to establish adverse possession, she is going to have to show that she had exclusive use of this property. And that simply isn't the case. It's essentially concrete between these two driveways, even if she sometimes used it or drove on it, as my clients did because it's their property. That doesn't establish any sort of adverse, hostile, or exclusive use to that property. And when we talked about it, that it doesn't necessarily have to be absolute exclusivity, but that she would need to be using that property in a manner that the true owner would at the exclusion of my client, and that has not been the case. Even Ms. Bittner talks about my clients placing flower pots and things of that nature on that property. They're using that property as they do the rest of their property. And again, this is property that both of them have driven over at various points in time. And so this idea that for any 10-year period that she would be able to have exclusive use over what is essentially a concrete driveway just isn't consistent with what she would need to show to be able to show adverse possession. Secondarily, we do have the survey that notes that there is utility easements that also run in this location. And while an easement isn't necessarily conclusive, it certainly is evidence that this property has underlying use that is shared with at least a utility company to be able to access and use this property. And again, she's not exclusively using that property in any manner. The plaintiff essentially, when she has talked about the use, really it is consistent with how you may drive over a portion of the driveway. And she at no point in time installed on that driveway a fence line or anything else. My clients are the ones who did that in order to establish this isn't a case where, 15 years ago, she threw up a fence line on that driveway and we've all been abiding by that fence line. This didn't have any sort of fence or any sort of boundary on it until the time that my clients surveyed the property and put up the fence line on the property boundary. It wasn't until 2024 that plaintiff started to place planters on this disputed property on that driveway area. So prior to that, from the time these parties have been out there, my client provides that she really wasn't doing anything other than driving across it. And so when you look at what you need to show to establish any sort of adverse possession claim, it would need to be that she used it for a period of 10 years, that she had actual and uninterrupted use of that property, that it was open and notorious in some way, and certainly driving every now and then across cement isn't open and notorious use of it, and that it would need to be hostile, meaning she was using it in the manner that a true owner would at the exclusion of my clients, and that simply did not happen. And there is no scenario that I can see that Ms. Bittner would be able to make a claim that would be successful for adverse possession over a portion of a driveway. Now, if we're talking about potential prescriptive easement issues, right, I think those are separated out. But really, when we're looking at this adverse possession, there is no basis for a claim for adverse possession for the driveway portion of it, certainly. My clients have had issues, and I'll get to it when in my response to Ms. Long. But when you look at what we would need to, what Ms. Bittner would need to show, really, we're looking at cases where people have used, maintained, and owned property at the exclusion of the owner. Or there has been some kind of fence line or boundary, which would have created some sort of acquiescence or some sort of ability for plaintiff to come to this court and say, yeah, this has been here. I'm the only one who used it. It was for a period of 10 years. And that defendants haven't even been on this property. But that's not true. The cement between the property has been utilized as the driveway for my client's property, and that is outlined in his declaration. It looks like there is a dispute between the parties as who placed it in the complaint. It indicates, I believe that she did, but in 1970, my clients indicated that they paid for the cement and poured it in the disputed area. That after they started to have issues, that they did obtain that survey, and that was done in May of 2024. And that they, in fact, did have had continuing issues as far as plaintiff and her daughter hitting the fence, attempting to move the fence, attempting to destroy the fence. And these are creating a difficult at best situation out there. But my client provides very clearly that he has utilized this disputed property for the entire time they resided on the property. And as you get closer to the house, when we talk about that sidewalk and even maintenance of the cement, right, there is blowing leaves, maintaining vegetation so it doesn't grow over things. They've done all of these things. So they've certainly used that property. The easement is 4 feet on either side of the property line. And again, that is marked on the survey. And 4 feet certainly toward my client's property that would be within that easement area is well outside of sort of what Ms. Bittner is claiming in this matter. So based off of the allegations in the complaint and the information as far as use and the fact, just quite frankly, the nature of this driveway property, we are asking that the court find summary judgment in my client's favor as to an adverse possession claim over that property.
Thank you. Ms. Long, go ahead.
So the fundamental problem with this motion for summary judgment is the argument that my client just can't possibly prevail on a claim for adverse possession because this involves a driveway. If there's case law out there saying that the claim of adverse possession doesn't apply to driveways in the state of Washington, I'd love to see it. But otherwise, what we have here is we have an established procedure for motion for summary judgment that has not been followed. In their own brief, the moving party describes their burden for a proper motion for summary judgment. It says, once the moving party furnishes factual evidence showing that he or she is entitled to summary judgment, the opposing party must produce specific facts responding to that. And in this motion, we don't have even like basic prima facie facts that are alleged showing that the defendant is entitled to prevail. They've just said, we don't think plaintiff can provide facts. So we're just going to go ahead and leave plaintiff to her proof and have her respond to this motion. I'm not going to go through all 4 of the elements because I don't think there's really a contention that my client's use was not open and notorious and was not continuous. The issues that I think need to be analyzed more closely are the elements of exclusivity and hostility. The case law is clear that exclusivity does not mean that my client has to be the only one that ever uses the driveway. And my client has offered evidence indicating that she allowed the neighbors, the defendants, to use the driveway with her permission. As to the element of hostility, both sides have indicated that, it's a concrete slab, and in terms of they both essentially have alleged that they would use it. They've used it as a true owner, and that's basically driving over it, blowing leaves off of it, and pouring new concrete when new concrete's there, or when new concrete's necessary. I don't know, in terms of my client pleading facts that she's used the concrete as a true owner would, I don't know how else a true owner would use a concrete pad. My client's has offered in her declaration testimony that she was the first owner of the property, that she and her husband poured the concrete, clearly establishing that they intended to use that land as a driveway. They built their house there first, and there's nothing else that they, as Ms. Tideman points out, there's not anything else that they could have done that would be more hostile other than putting up a fence. And as you can see from the photographs of the property, particularly Exhibit 5 to Ruth Bittner's declaration, you can see the problem that putting up a fence does. It means that only one person can use that driveway, one or the other. And so the defendants have decided that what they're going to do is put up a fence that makes it so that my client can no longer basically make use of that area. And so that's why we're here today. I have other arguments to make, and points to make, but those are more related to my motion for fees.
Ms. Tideman, do you want to respond to the substance before we move on to the other?
Yeah,
Okay.
my response would be that my client is the true property owner. We have a survey showing that my client is the owner of the property. So I don't have to establish every element of an adverse possession claim because I'm not the one making the adverse possession claim. What we have to do in a summary judgment motion is establish what the plaintiff would have had to show in order to prevail. A plaintiff has to show all of those things. Those are all things a plaintiff has to show in order to prevail on an adverse possession claim. I don't have to poke holes in every one. I have to show the court how she won't prevail on some of the elements necessary in order to make the adverse possession claim, which is what we have done in this motion. I don't have to prove an adverse possession claim or that we had exclusive use of it or any of those things because my client is the true property owner. We are here on a summary judgment because plaintiff has said, I have established, I believe, adverse possession over this piece of driveway. And we're saying you have it. And while we can agree that she has utilized that cement in some fashion, use of cement is not exclusive use. She has to establish an exclusivity element of her adverse possession claim in order to make it be able to go forward. And so for me for there to be an allegation that I have to somehow come or my clients have to somehow come and make proof of every element, that's not true. What we have to do is show how the plaintiff cannot prevail and how all of the facts are in my client's favor, and there are no material facts as to her exclusive use of this property, and that is what we have done in this motion. The argument made by the plaintiff in this motion is essentially, because we both used it, I should still have a claim for adverse possession, admitting that they both used it. But that is not the standard. Otherwise, why would we ever have a prescriptive easement claim, right? If two people are using the driveway and they have for 10 years, why wouldn't those all be adverse possession claims? But they aren't, because concurrent use of the property destroys an adverse possession claim. And that is what's happening to plaintiff in this very case. So I don't have to establish all the elements. We have shown where plaintiff cannot meet her burden. It is her job on response to the summary judgment to meet that burden and show that she can establish those things. And her own pleadings indicate that these people have both used this property. If both people are using the property, my client prevails because my client is the true property owner, and that is the basis of our claim.
Let me, along those lines, Ms. Long, let me ask you, so, one of the things when we're looking at this is that the use by the parties wasn't more than a neighborly accommodation. And so in your response to motion for summary judgment on page, what page am I at? 3. It basically says, plaintiffs, and believing it to be theirs, plaintiffs allowed defendants to use the disputed property for the limited purpose of driving over the portion between the two driveways when defendants entered or exited their parcel's driveway. They only gave permission to encourage a neighborly association. And then later down, it states that they didn't object to defendants leaf blowing the disputed strip or pressure washing it, again, out of a neighborly accommodation. And so it just goes on to talk about the defendants leaf blowing, sweeping, pressure washing. So I guess my question is, if the legal boundary was reversed, your client had true legal ownership, and without getting into adverse possession, but true boundary shown legal ownership, they would be conceding neighborly accommodation. How is it not the same? So your client's saying we, through neighborly accommodation, let defendants use it. Neighborly accommodation to me connotates some sort of back and forth where both parties are being neighborly with each other. So I guess how does that not negate adverse possession? Just by your client's statement that there was a neighborly accommodation that defendants could do what they wanted.
Well, one thing that maybe is that I don't think is spelled out very clearly in the response, and I'm not, I can't recall with certainty how clearly it's spelled out in Ruth Bittner's declaration, but when she says it wasn't practicable to prohibit from the defendants from leaf blowing, sweeping, or pressure washing areas of the disputed strip, she's not saying I let them come over and clean my driveway. She's saying they would leaf blow their yard, but you know, the leaf blower, you can't stop where the wind, where the wind hits your driveway, it's going to keep going. Same thing with sweeping and pressure washing. It's not that she invited them or let them come over and pressure washed the disputed strip that she's now claiming she owns. She's saying that there's no line drawn. And so to the extent that, I mean, she can't say under penalty of perjury, they never ever swept any portion of my driveway or, pressure washed a tiny bit of it. Of course, things like that are going to happen. That's what she's saying.
But I guess, and I understand that, I guess what I'm getting at though is if she's saying, and now I'm paraphrasing, I'm not taking this verbatim, but here's the gist I get as I read it. Plaintiff is saying, yeah, we let each other, we both used it and we let each other use it because we were trying to be good neighbors to each other, which does defeat adverse possession.
No, it does not.
How does it not?
Because there's case law that says that adverse possession is not defeated by the true owner allowing, or the adverse possessor allowing someone else to use the property.
Well, but you have to prove hostility.
You do.
So nothing here, and again, I'm paraphrasing when I say that it sounds like these parties were like, hey, we can both use it and we get along until we don't. But for now, for most of the 70s, 80s, 90s, and 2000s, we get along. And great, we can use this disputed cement strip. So just, I don't sense the hostility. That's what I'm trying to get. Like, where's the hostility?
I'm just looking at the hostility section of my brief.
Yeah, of course.
It does seem like the hostility portion of the brief talks a lot about the fence that both parties allowed to put on the agreed, what was the agreed boundary line.
Okay, let me catch up with you there. Okay,
Sorry, are you waiting for me? Am I waiting for you?
no, you're waiting for me. Sorry, I'm just trying to comb through. So, okay, so it seems like the hostility, help me out. Here's the most I can make of that is that there's potentially a hostile possession of the back portion of the disputed property. So I guess when was so that statement, there was a fence that precluded defendants from going onto the back portion of the disputed property. When was that put up?
In the 2000s.
But that's not the 2024 fence, is it?
No, that's a different fence.
Okay. So early 2000s.
So in the early 2000s, both property owners agreed that they would put a fence up along what was the agreed boundary of the property. And I don't know how well this shows up in the pictures that were submitted to the court, but the fence went along the area where you could put a fence. It didn't go over into the concrete. And so my client's argument is that that establishes the boundary line for as far as you could establish it without basically making
So is it,
basically without making it so that my client can no longer make a neighborly accommodation.
is there, Ms. Tideman, is there, I guess, what is your client's take on that there potentially was, for a period of 10 years, a fence on the back portion of this disputed strip that they were not allowed to access?
So they would dispute that they weren't allowed to access as they maintained trees and shrubbery and took care of varying things, is my understanding. And when we received the materials, we didn't understand that that was going to be a clear delineation, I guess, in the argument as far as because that wasn't stated when that was put up or that that was an argument being made. We could have then replied with that information, but the information is there is on the very back portion. So none of this has to do with the actual driveway itself, if that makes sense. Like close to the house, there was a fence that was put up. I don't have the date sitting in front of me. And then secondarily, my clients indicated that they did maintain vegetation and things on both sides of that fence line.
Okay. Anything else from either party on that? And then we can talk about the motion for fees.
No.
No, Your Honor.
Okay. Well, here's how I see it. And, I know, we're not here in a full-blown trial with all the facts presented and credibility of witnesses determined. I'm gonna deny the motion for summary judgment. I think I'll tell you, I waffled as I read through this a little bit. I am concerned whether plaintiffs can truly show hostility. But I think two things. I think it's a bit of a credibility determination that for purposes of summary judgment, credibility determination should be left to a trier of fact. But also, there does seem to be some suggestion maybe that a part of this disputed strip might have been blocked off for use by defendants. And in which case we're dealing with, if I were to grant summary judgment, I really don't know that what part of the disputed strip I would be granting and what part I would be sending to a trier of fact. So I think there's some things to flush out from a factual standpoint. I also, if I was this trier of fact, I would want to know when that fence was put in specifically on the back area of the disputed strip. So again, I will be perfectly honest, I waffled on this one back and forth numerous times reading through it. I think because of that, it tells me that there are some material issues of fact that I can't resolve here on summary judgment. So I'm going to deny and allow the issue to go to a trier of fact. Do the parties want to be heard on, well, I guess Ms. Long, do you want to be heard on the fees and costs request?
Yes.
Okay, go ahead.
Okay, so my client spent a lot of money responding to this motion for summary judgment that after it was all said and done, defendants said prior to this hearing, never mind, we'll just withdraw it. The motion for summary judgment was filed on December 1st, 2025. Associate Jamie Zeiser in my office on December 17th emailed Nicole Tideman and said, among other things, please go back and fact check and cite check your motion for summary judgment brief, as we have, after spending hours of our own time doing so, found a large number of material errors. I also invited opposing counsel to refile or to file a supplemental brief at that time if she wanted to. We talked about how this had been reset a number of times. I'm not gonna get back into that, but I do count 3 times when it was continued at the request of opposing counsel. When I look through and this is kind of separate and apart from the merits of the summary judgment brief, but you know, judges, all judges formerly were practicing attorneys, and so they're all familiar with the issues associated with trying to respond to a summary judgment brief that, just to put it bluntly, is not well crafted and it's not checked over. For example, on page 2 of the motion for summary judgment, it says plaintiff has owned her property since March 11th, 1980, and it cites the declaration of Nicole Tideman. That's false. All you have to do is look at the assessor's records and pull the deed showing that my client bought the property in 1978. And the declaration of Nicole Tideman does not contain a reference to that. That's not something that she can testify to based on personal knowledge. And that deed isn't attached to her declaration. So that's not a proper citation, which I brought to her attention, and she still refused to fix it. And so then we have to file this brief saying, this is false. Here's why it's false. Here's a copy of the deed. We'll do all the research and indicate to the court what the true facts are. Then there's an unsubstantiated statement that says, also on page 2, plaintiff did not reside on the property until 14 years prior to this action. No citation given. I have no idea what that means. Then later on page 2, defendant James Gray gave permission to Grant Bittner in 1977 to drive over the portion of property that is the subject of this lawsuit. That's an important allegation because, as we know, permission is a big issue when it comes to adverse possession and prescriptive easement claims. That's false. Grant Bittner did not own the property until 1979. And again, that's what the land records show. So I don't know what to do with statements like that when somebody's making a declaration under oath about something that is critical to the case and is wrong. Then on page 3, there's allegations that Sharon Bittner, who is the plaintiff in this case, allegedly has been made the defendant and found guilty in connection with an anti-harassment order. Sharon Bittner is not a party to this case. Sharon Bittner is Ruth Bittner's daughter. And, most of James Gray's declaration seems bent on incorporating the allegations of that protection order against Sharon Bittner and Sharon Bittner's alleged violations and turn that into a basis to put an injunction on my client, Ruth Bittner. There's various parts of this motion for summary judgment where Sharon Bittner is referred to as the plaintiff, where I can't tell if who they're really talking about is Sharon Bittner, if they're talking about Ruth Bittner. On page 3, there's an allegation that says the concrete continues to defendant's home for the rest of their driveway. And then it says, see declaration of Nicole Tideman. There's nothing about the concrete in Nicole Tideman's declaration. On page 5, they repeat the allegation that plaintiff has owned her property since 1980. And then, ultimately they're asking this court to enter an injunction against Sharon Bittner, who's not a party to this action. So ultimately, my client is just really frustrated by the amount of time that we had to spend responding to a motion that contained a large number of factual and accuracies and citations to documents that did not support those citations after we asked opposing counsel to please take a look at her brief and make sure that everything in there was accurate and, you know, not a misrepresentation to the court.
Ms. Tideman, go ahead.
Thank you, Your Honor. For the record, what I will say is, when we filed this motion, Ms. Long office originally had filed to amend the complaint and then failed to ever serve that complaint. And that was part of our initial filing that we had made because they simply had never filed or served. Maybe they filed it, but we had never been served or never received a copy essentially of the amended complaint. And I think it had been a year or so after that had gone through. When I got Ms. Long's email about a supplemental brief, quite frankly, my thought was that that was related to the fact that we had agreed to set over the original hearing so that they would have an opportunity to file that and that wouldn't be an issue at summary judgment. And I was willing to do that. At no time, and I'm going to be honest, I mean, part of it is that sometimes things potentially, I have regularly, when I've dealt with opposing counsel, if anything has come up, that we have made a record of it just at the beginning of the hearing as far as if there were things that needed to be clarified or corrected, and that was how I've always handled it. When we got the response, that was my plan to handle it in that manner. And I will say, my brief certainly should have said plaintiff's daughter, and it said plaintiff in part of it. That's on me for not, having that in there, but it later in the brief does say her daughter. So it wasn't like it was consistent throughout the briefing, but again, I'll take ownership over the fact that that was a typo in my materials, and my plan was just to address it simply with the court, as I have done many times before, without any issue with opposing counsel or the court. And I know we're in front of another judicial officers and people have different, takes or different ways that things should be handled. That is, like I said, how I've handled that with other people that way, and I've handled it with myself that way. I did offer to essentially withdraw it so that we could refile it to correct anything. That request was met with a response that essentially they would still continue to move forward with this. And so we did try to essentially indicate that we would do that, or at hearing, make any corrections. Again, I think it's probably inconsistent because one part of it did indicate plaintiff for that, and the other part said her daughter. So it is spelled out in there. It wasn't a misrepresentation as far as me making that claim over and over and not supporting it. Both my client's declaration indicates it's Miss Ruth Bittner's daughter, that's Sharon, and both my pleading also later indicates that. But I guess my frustration with some of the things that were pointed out and quite frankly responded to are some of the things that just might be complaints and argument and summary judgment, but aren't necessarily things that would rise to what counsel is essentially trying to allege. We did file the declaration of Tracy Doley. I don't know if people have resided on the property in an ownership that is a deeded ownership, or if I have information like we did from Ms. Doley that her parents were there, that there wasn't some independent contractor, some other way that they potentially were on that property. But what we did get is we got a declaration that had been sent to us from Tracy Doley that we used to assert some of the things that are now being complained about. So we had a secondary declaration from somebody within that family that provided that information to me. And there was a secondary check of that, including the agreement that Grant Bittner could drive over the property that is at issue in this case. So it is supported by facts and information. There was an investigation done. We have a declaration that supports that. And again, property records deeds don't always necessarily show things that have happened as far as independent real estate contract or other things that sometimes can happen in the background. And I am surprised in these real estate cases how often there is oddities that exist in the past. If something is factually disputed, then that is a factual dispute that we argue at summary judgment. And that is the basis for most of these motions. One party says, the cow is white, and the other says it's black. And then we tell the court why the court should believe what we're saying. But to point out, my client in his declaration relies on Tracy Doley in part for the information he received. There's a complaint that my client said that there was a good relationship. That is my client's perspective. There's an allegation that my client's declaration was incorrect because he provided permission to the previous owners. Again, that was directly from Tracy Dolly, who had indicated, had supported that contention, and we had supported that. Now with, I provided an essential response to this to say, yeah, we had other information that supports that contention if that is an issue. There's a complaint that my client said he's maintained vegetation, but then admits the entire strip is covered in concrete. We just had the whole conversation about how there's a back and front pour and how there's vegetation and how people were doing various activities to maintain. So that is supported. Just because it is not agreed by plaintiff doesn't mean that it is some sort of false or incorrect statement that's being made. Again, as far as the complaint about the request for the harassment issue, I've regularly gotten orders in these cases that are injunctive relief as a result of a summary judgment that prevents the plaintiff and their agents or others at their instruction from doing any harassment. Obviously, that is only controlled so much as far as who is an agent plaintiff, but that is a regular thing that I have requested and never had a complaint that that request would be incorrect or unsupported. There's complaints in here that, you know, defendants have owned their property for approximately 47 years. That is in fact correct. Their own complaint indicates that these parties have owned the properties for over 40 years. So it's hard for me to respond to all this when we're just complaining about things that, quite frankly, most of these are just things that are potentially disputes as far as what the parties believed happened. But some of that is supported by their own complaint that also indicates that everybody's owned these for over 40 years at that point. We just did the math. In 2026, it's 47 years. We have the complaint that James Gray gave permission to grant Bittner. Well, that is supported by a secondary declaration. And again, that was supported by information that I had. So we did, in fact, make that statement. There's an allegation that the property in question had nothing on it. That was as far as that front part. Everybody admits that there was nothing on that. So that is an accurate statement. Allegations as far as the complaint about citing 4 elements of adverse possession. Again, I've already addressed that. I don't have to. The plaintiff is obligated to make that prima facie case. My job is to file a summary judgment that points out where they're unable to meet an element of an adverse possession claim. And Your Honor said you went back and forth on it. So certainly our motion had enough behind it that it caused the court pause. This wasn't a frivolous motion that wasn't supported by anything. We were talking about what Your Honor talked about, which is at this point, this concrete where even plaintiff admits there was concurrent, at best, concurrent use for her. There's complaints that adverse possession can't be made where it is utility easement. That's not the claim. We just indicated there was a utility easement and it goes to an exclusivity element of it. There's just a number of things, you know, conclusory statements of law. Well, it's a brief. I'm making conclusions and argument in my brief. Absolutely, I'm doing that. Complaints about that there's a statement that appropriate steps to resolve the issues, but blame a non-party for these issues. My client are providing what's happening and what the issues are. So my issue is, one, if you're going to seek this kind of relief and I offer to correct or do what I can because of a typo, I'm happy to do that. Things happen. I'm not perfect. That is the reality I live in. CR 11 requires that I be given that opportunity. 2, an email that says, hey, you can file a supplemental brief when there's been an amended complaint that hadn't been filed, that I allowed time to be filed. So before this motion, my understanding of that was that we were going to allow me to do that if necessary, based off the fact that the amended complaint had now been filed. Under no circumstances did I understand that this would be sort of what the contention is moving forward. But again, I have handled these things routinely like this previously. I've allowed other attorneys to do that. I guess if the court takes issue with the typo, I will accept that, and that is the lot I will have in life. But by no means do I think that I did anything that would warrant sort of this kind of relief. And two, our documents that were provided were supported. I just want to raise one other thing. One of the things Ms. Long talked about is that I reference the concrete portion in my declaration that references the survey that outlines where the concrete is. So my declaration, in fact, does reference the reflection of that concrete between the driveways. And I appropriately referenced that within my declaration.
Okay, Ms. Long, anything briefly?
The only thing I'll add is, Ms. Titan made a representation to the court about conversation that we had prior to this, where she offered to correct the typos or the misstatements. That offer was never made.
So here's what I go to for this type of request. You know, I am looking at whether sanctions are appropriate because either the findings aren't well-grounded in fact, they're not warranted by existing law or legal argument, the filings are interposed for some unlawful or improper, should not say unlawful, improper purpose, or there's some denials that just aren't factually based. I will be very honest, when I started reading plaintiff's request for motions, for fees and sanctions in the motion, the request kind of initially was phrased as, hey, we found some improper citations in your brief, please go back and correct. And I thought what I would be uncovering was some just either blatant, you know, cases that don't exist, as we've all heard about in the news lately, or I guess something more than what I found. And when I went and compared the list that plaintiffs listed as far as what they saw as wrong, yeah, are there a couple typos? Yes. Have I made typos in my own rulings? Yes. So I don't find anything from a typo standpoint egregious or warranting of in sanctions. I guess as I went through the list, it was very clear to me that these are factual disputes that plaintiffs think are wrong, but defense has some evidence for. So I can't, again, you know, not being the trier of fact of the ultimate issue at this stage, say that plaintiff is absolutely right in what they say and defense is absolutely wrong. I also, I guess, struggle a little bit with the idea that I understand civil litigation is expensive and I wish it on no one. And that's having been a civil lawyer. But, you know, plaintiffs did file this lawsuit. I understand it is getting costly, but ultimately the burden of proving these facts is on the plaintiff. And, you know, a summary judgment by a defendant can be filed for two reasons. It can be filed because they think summary judgment is by law, they are entitled to a ruling, or they can file summary judgment saying, Judge, we don't think plaintiff can prove their case. Here's why. And then plaintiff has to prove their case in summary judgment. And the latter is where we find ourselves in this case. So, you know, kind of regardless of some of the disagreements between counsel, ultimately the plaintiff would still have to prove these things and unearth them. So I think in balance, I understand plaintiff's concern about what they view maybe as misleading, where it talks about Sharon versus the true plaintiff. It wasn't difficult for me to parse through those two differences. But I understand. I understand that having someone say 5 when you know it's 6, and I'm just using that as an example, that can be frustrating, but I don't think anything was done intentionally or egregiously. So although I have denied the motion for summary judgment, I don't think it was filed frivolously or with improper purpose or intent. So I'm going to deny the request for fees and costs, but also deny the motion for summary judgment.
Okay, thank you, Your Honor. Do you
Yeah.
need orders?
You know, it probably would be helpful, just a quick agreed order listing the filings that you all made that I relied upon and denials. And we can do that ex parte, I'm sure, unless you want me to set it over 2 weeks for presentation. It's really up to you.
I think I'd prefer just to set a presentation just for a placeholder.
Okay.
I've learned
Yeah.
I'm not
We
always
could,
great at
yeah,
remembering they're outstanding.
it keeps us all on task. June 3rd at 2 o'clock would be my next docket.
Okay, and my hope is if council and I can work out orders, then we'll just strike that hearing. We won't need it, but it keeps us on track to get orders entered.
Yeah.
That work? Okay, sounds good. Okay.